Hi, so today we're going to be learning about the jurisdiction of the Supreme Court of Nigeria. In the Supreme Court, of course, in terms of constitution of the court, you have five justices who sit to entertain any proceedings. But there are certain instances where the Constitution says it has to be at least seven that sit for the court to be properly constituted. Now, those three instances in which you would need to have seven and not five sitting are one, where the Supreme Court is exercising its original jurisdiction, two, where it's a matter that involves the interpretation of the Constitution, and three, where it's a matter that involves the contravention of fundamental rights under Chapter 4 of the Constitution. So those are the three instances where in the Supreme Court you would need seven justices sitting and not five. Now, the first instance says matters in which the court is exercising its original jurisdiction. And of course, when we talk about the original jurisdiction of a court, we're talking about cases in which the court acts as a court of first instance. So in the Supreme Court, in what cases, in what circumstances does the court sit as a court of first instance? Now, in the Constitution, there are two subject matters that are provided as instances in which the court has original jurisdiction. Now, one is in those proceedings between the federation and a state, and the second one is in proceedings between one state and another state. So if, for instance, Lagos State is suing the federation, that's the federal government of Nigeria, for withholding maybe the monthly allocation for Lagos State, the Supreme Court is the court that would have jurisdiction to entertain that proceeding. Likewise, if, for instance, Niger State is suing Kwara State over some border dispute, again, the Supreme Court would be the court that would have jurisdiction to entertain that case. So those are the two subject matters in the Constitution where you find original jurisdiction vested in the Supreme Court. Now, you also have an act of the National Assembly known as the Supreme Court Additional Original Jurisdiction Act. It was enacted in 2002, and it conferred three additional original jurisdictions on the Supreme Court in the following matters. One, in disputes between the National Assembly and the President. Two, in disputes between the National Assembly and the state. And three, in dispute between the National Assembly and the State House of Assembly. So these are the three subject matters in which, under the Supreme Court Additional Original Jurisdiction Act, you have original jurisdiction conferred on the Supreme Court. So totally, there are five original jurisdictions of the Supreme Court. One, in disputes between the federation and a state. Two, in disputes between a state and another state. Three, in disputes between the National Assembly and the President. Four, in disputes between the National Assembly and a state. And five, in disputes between the National Assembly and a State House of Assembly. Now, the last thing I want to point out here is that when you see the federation, as it's stated in the Constitution, and when you see the President, as it's stated in the Additional Original Jurisdiction Act of the Supreme Court, is the same person or entity in question that it's referring to. So that's the original jurisdiction of the Supreme Court. In terms of the appellate jurisdiction of the Supreme Court, basically all appeals from the Court of Appeal are heard by the Supreme Court. And in terms of the finality of the decisions of the Supreme Court, all proceedings the Supreme Court hears terminate there. Beyond the Supreme Court, there is no additional court that can adjudicate. So that's a quick summary of what the jurisdiction of the Supreme Court is like. I hope you've learned something new today. And I'll see you again some other time. Bye-bye.